everyone, and welcome to our panel discussion on the differences in USA and EU's regulation on the crypto market. I'm so glad to see the great turnout of this event, and I'm certain that our audience is as excited to learn the latest developments of crypto regulation on both sides of the Atlantic as much as we are excited to share our professional insights on what's actually happening on the ground. Using this opportunity, I'd like to share my delight on the noticeable growing interest in this topic from both new companies exploring investment opportunities and already active companies looking into the future of their activities by consulting on the best ways to implement the upcoming requirements of MiCA regulation in the EU. This brings me to the topic of our discussion. As I'm sure most of you are aware, earlier this year, the EU has adopted the Markets in Crypto Assets Regulation, or just MiCA. The regulation intends to provide a single harmonized body of legislation to regulate crypto asset activities in the EU. Due to the enormous scope of the regulation and its effect on the market, it's being implemented in stages, whereby the regulation will fully be implemented by the end of next year. As the deadline for its implementation is just around the corner, we've noticed an ever-growing interest to know more about who and what this regulation will affect. In that light, we thought it would be an excellent idea to share our insights and in cooperation with our US partners from Pryor Cashman law firm to make a comparative discussion on the new regulatory developments in crypto regulation. So today we are going to explore what the major regulatory trends in the US and EU are and provide some guidance to our audience on what crypto asset market participants should be aware of if they are already issuing crypto assets or actively providing crypto services, or if they are probing for the best environment for their businesses. In particular, we will cover who is subject to regulation, what is regulated, what is the market's response to the regulation, and how can we, as lawyers, help crypto market participants to navigate the complex world of crypto regulation. So, moving forward, I'd like to introduce you to our today's speakers, starting from our colleagues from the United States representing Pryor Cashman's FinTech practice. We have Jeffrey Alberts, partner and co-chair of Pryor Cashman FinTech practice in the US. Jeffrey, could you please introduce yourself?
Sure, happy to, Inga. And thank you so much for inviting us to participate in this webinar. So my name's Jeff Alberts. I'm co-head of the FinTech group here at Pryor Cashman. I'm based in New York, and I guess I should just give you a brief overview of our FinTech practice. We represent companies that are based outside the United States who are interested in engaging in FinTech activity here in the United States. And we advise on US law that applies to FinTech companies, which includes cryptocurrency companies, payments companies, online lenders, and other forms of financial institutions that are not subject to banking regulation.
Thank you. Bertrand Fry, partner and co-chair of Pryor Cashman's FinTech and investment management practices, and a member of the corporate group. Bertrand, please.
Thank you, Inga. So as you said, with Jeff, I'm the co-chair of our FinTech practice area. I'm also the co-head of our investment management area, and there is also increasingly an overlap between the investment management practices and our clients there and FinTech. So certainly in the digital asset space, we help people on the corporate side, and my focus is on the advisory and structuring of corporate structures for FinTech. You know, we help them set up their businesses. We help them with token issuances, but we also help people who are looking to trade and perhaps participate in those markets as software providers or as ancillary participants in this industry.
Thank you. And our own very own ECOVIS Preventus team specializing in servicing financial institution, banking, and crypto. So Kęstutis Klainauskas, partner and attorney at law, with over 20 years of legal experience in banking, and Kęstutis is acknowledged for his proficiency in incorporating and licensing financial institutions, brokerage firms, investment funds, crowdfunding platforms, and other institutions within the single European market. And his extensive knowledge extends to crypto assets and blockchain licensing, making him a sought-after authority in this innovative and dynamic industry. Kęstutis, would you like to add?
Thank you, Inga. I suppose that's enough. Just to save the time, I would like to pass the stage to Tautvydas, probably.
Okay. So Tavi Petros, our associate advocate's assistant and early adopter of crypto, gathering technical insights into the industry dynamics since 2017, and currently a recognized expert in the MiCA regulation, advising world-renowned crypto industry leaders and guiding newcomer clients through the complexities of crypto regulation. Tavi?
Hello, everyone, and thank you for having me.
Thank you. So, and last but not least, me, myself, moderator. I'm a partner at ECOVIS Proventus Law with several decades of legal expertise, and I'm specializing in anti-money laundering and sanction spheres. As well, I'm a board member of the FinTech Association and consult on different compliance issues, risk management, PSD2, PSD3, and other financial regulatory questions. So without any further delay, let's jump into the first topic of our discussion. Jeffrey, could you please briefly explain to us the organization of the current regulatory regime for crypto in the United States?
Yes, I can. So I guess to start out with, it's good to know that here in the United States, there hasn't really been an overarching law that has been passed that regulates cryptocurrency companies. So instead, you have a number of different federal regulators who have all sought to apply laws that have been around for some time, in some cases over 100 years, to new cryptocurrency services that are being provided here in the United States. And not only do you have a number of different independent federal agencies that are all involved in this process, but as we'll discuss later on, they sometimes fight with each other and have different interpretations of how these laws that have been around for a long time apply to new cryptocurrency services that are being offered. And on your screen now, you have an alphabet soup of different federal agencies here in the United States that all regulate different aspects of cryptocurrency services. I'm going to try to give a quick high-level overview and walk you through so you have some idea of what you might be facing if you seek to do business in the US. So to start with, the top two categories that you see listed on your screen are the SEC and the CFTC. So both of those are federal agencies that seek to regulate investment activity. The Securities and Exchange Commission is focused on the regulation of securities, and the CFTC, or the Commodities Futures Trading Commission, it regulates commodities, and in particular, derivatives and certain forms of futures transactions that involve commodities. Now, why are they both involved in the regulation of cryptocurrency? Well, the CFTC says that digital assets are commodities. The SEC says that nearly all cryptocurrency assets are securities. So both of them are simultaneously trying to jump in and impose their broad general regulations to cryptocurrency transactions. The next agency that you see listed on your screen is FinCEN. So FinCEN is within the Treasury Department. It's the Financial Crimes Enforcement Network, and they have a different focus. So the first two agencies are focused on protecting investors. FinCEN is focused on preventing crime. So they come in from a different angle, and they tend to be focused on money transmission, or in the case of cryptocurrency, the transmission of what they call convertible virtual currency. So basically, they're trying to ensure that when transactions take place that involve cryptocurrency, it doesn't involve money laundering. So transactions with proceeds of criminal activity. The next two agencies that you see listed here are the FTC and the CFPB. So the FTC is the Federal Trade Commission, and the CFPB is the Consumer Financial Protection Bureau. Both the FTC and the CFPB are focused on protecting consumers. and ensuring that there's not unfair trade practices being engaged in by companies. So with respect to cryptocurrency tokens, their angle on who to protect ends up being kind of similar to the SEC and CFTC. It's just that the SEC and the CFTC are focused on purchasers of cryptocurrency as investments, whereas the FTC and the CFPB tend to be more focused on them as consumers. And in a lot of instances, they can end up really trying to enforce the same general principles, but they can diverge, for example, in the area of NFTs or non-fungible tokens, where sometimes you just have like sports trading memorabilia and that type of thing that is being exchanged on the blockchain. And that often is not necessarily an investment, but is still viewed as a transaction that involves consumers. The last category that we see here are the banking regulators. So that's the FDIC, the OCC, the FRB, and the NCUA. I'm not going to break down what all of those terms stand for, but they're basically all regulators either of banks or in some instances of other forms of financial institutions that are very similar to banks. Now, these banking regulators generally don't regulate the cryptocurrency industry directly, but they tend to have a strong indirect involvement because cryptocurrency transactions are usually engaged in by companies that also have bank accounts. And if they have those bank accounts and those bank accounts end up receiving proceeds of cryptocurrency business or cryptocurrency transactions, then the banking regulators get involved because they're very involved in making sure that their bank doesn't improperly provide services to fintech companies that are somehow either endangering the bank or otherwise engaging in unlawful activity.
Thank you, Jeffrey, for that overview. It really sounds like there is a lot of overlap and even tension maybe between federal and state regulators in the US. So, Bertrand, can you explain how the laws change in the US, both at federal and the state level?
Sure. It may be worth noting that the US system, maybe facially, is quite similar to the EU system, but when you really look at it in detail, they differ quite significantly. In the US, the federal and state regimes really operate in parallel and separately. So, for example, the federal laws don't promulgate a broad rule that then is enacted by the states on a statewide basis. Instead, there's a federal rule which may conflict with state rules. In some instances, if there's a broad federal rule, it'll preempt state action with regard to that same area. So in a lot of the financial industry regulatory regimes, there's a preemption by the federal regulator so that states may require light regulation, notices, sometimes filing fees, but they can't actually have a regulator who is involved in the administration of that business. In other places, banking, some lending activity is an example. Some lending activity is regulated both at the state level and federal. So this creates a very treacherous environment for people in the digital asset area because you've got when you have a DLT, which doesn't really have boundaries, state or international, and yet you have an activity that in a given regulator in a state may feel their regulations apply to, you can find yourself with programmers in Estonia or Lithuania who now have to be complying with a rule that's based in Nevada and being implemented, I should say, by local enforcement regulators, right? So people who really mostly deal with things that happen within their state. How these laws change, the easy answer is inefficiently and not very often, but obviously we've had a difficulty at the federal level because our Congress is somewhat paralyzed right now. More critically, though, in this specific area, it's been very difficult to see federal regulation for a couple of reasons. One is legislators are not that familiar with the space and are becoming more familiar with it. There's been extensive lobbying activity by the digital asset community, and that's having some impact. With things like FTX's demise, it's becoming more evident, to go back to the investor protection thesis that Jeff was talking about, that there is a strong interest in having some regulation. And I think even the industry itself, which has kind of libertarian roots, is starting to see that some regulation would be helpful because with some guardrails, then people could really innovate. But the other big problem for the regulators, besides expertise in the area, is that the innovation is so rapid that it's hard to figure out what the rules apply. And a paradoxical consequence of that is that the regulators, the SEC and the CFTC, have often taken the position that their existing rules are fine. And some of the rules may go back 100 years. And the key test that we'll talk about later, the Howey test, dates from the 1940s. But the regulators have put themselves in a position of saying that they don't need a new law. Their existing rules do apply to these assets, and the participants should just comply with them. So the short answer is, we're hoping to see some legislation, something like what you've got coming out now in Europe, but we seem a long way from that. The other issue for us that we've seen over the last few years is what people refer to as regulating by enforcement. So the SEC in particular, but the CFTC to a certain extent, have views internally about how their existing rules should apply to these assets, and they're presenting that in large part by litigating against participants in the market. So with Ripple, with Coinbase, to a certain extent FTX, we're seeing the SEC going after participants, and by the settlements that they achieve, we're then seeing what the state of the law is. And to the extent that now that we have litigants who have both the willingness and the financial wherewithal to battle those cases all the way to an actual firm determination by the courts, the SEC in particular is finding that the courts don't always agree with their views, but what we are ending up with is kind of an additional complexity that a lot of the actual applicable law is going to be driven by court decisions, which makes it honestly even more fractured. So that's one of those are some of the ways that the laws are being promulgated. We'll probably talk a little bit about the framework the SEC has put out later, but there are various regulators have tried to provide guidance, but that's often been very conservative, and so difficult to comply with, or basically has the appearance of quashing innovation.
Mm-hmm. Very interesting, and thank you, Bertrand. Really, it sounds like a little bit different from European way, actually. So, Kęstutis, could you, drawing from the main points of that overview of the crypto regulation efforts in the US, present to us how different is the EU's crypto regulatory regime?
Yeah, we have the current regulatory regime and we have the prospective regulatory regime when the MiCA regulation will come into the force. But at the moment, I would like to tell you a bit more about the currently existing situation. To be honest, the situation in Europe is a bit chaotic, and the crypto licensing regime in Europe is not so different from the US until the MiCA is not fully implemented and enforced. Pan-European crypto license currently doesn't exist, and just speaking into US understanding, there is no federal crypto license in Europe. All the licenses in Europe are issued by the EU states only, and all these licenses are national. Usually there are two main activities the EU member states are licensing or trying to authorize. There are activities of the crypto exchange and the crypto wallet service provision. In some countries, there is additional regulation for the issuing of tokens in primary market, it's kind of initial coin offering or similar procedures. Some countries, they also introduce the additional capital requirements for the companies holding crypto license and additional national anti-money laundering reporting requirements. A single conclusion can be made from the current national regulatory efforts for crypto regulation is that most of the regulations are of reactionary type, meaning that they are not designed to solve the deep-rooted problems, but rather applying for the, let's say, quick regulations, just reacting into the ongoing events. Secondly, what is important to stress is that this chaotic national regulatory environment opens the door for the jurisdictional arbitrage. The companies are moving through the jurisdictions from one country to another country. For instance, that's in the very beginning, a lot of companies got the Estonian crypto licenses. Estonia was one of the pioneers in Europe introducing crypto regulation. Later, when Estonia introduced additional requirements, a lot of companies moved to neighboring Lithuania. And now, when the Lithuania also strengthening the requirements, a lot of companies are currently moving west to Poland, which regulation currently is considered as one of the most liberal in Europe. National authorization of crypto company in one of the EU countries do not necessarily is solution for all the European Union. Regulators in other EU countries may ask for additional authorization or introduce the additional requirements in their own jurisdiction. For instance, currently we have one US client holding Lithuanian virtual asset service provider license and additionally seeking further authorization on behalf of the same Lithuanian company. And the additional authorization they are looking for is Italy, Spain, France, Germany, and Poland. The biggest European countries might be covered under the same, let's say, Lithuanian company holding different authorizations in different countries. However, the next year, the situation is going to change completely because of the EU is currently in process of harmonizing its own common view on crypto across all member states by implementing MiCA regulation that will standardize the crypto regulation across entire European Union and common European market. This move will definitely create the clear and transparent pan-European licensing regime and common pan-European regulation, and probably establish much more attractive business environment covering all European economic area with a clear legal certainty that is probably necessary for the bigger long-term investments into the European crypto and blockchain sectors. Yeah, that's all. Thank you.
Yeah, thank you, Kęstutis. It's really very interesting that in the EU and US we have similar goals in mind. Yes, to regulate, to understand how to help this industry. However, the approach to achieve these goals are significantly different. I'm just wondering, Bertrand, what do you think? Would the same regulatory approach as in the EU could work in US, just starting from the legal regulation, not from enforcement and not from the court decision approach? What do you think?
In theory, definitely. I mean, and I think it would be great if we could get that. One of the difficulties that we have is the existing fissures between regulators, right? The SEC regulating securities trading, the CFTC regulating commodity futures. These are pretty hard to break. And so in a few times we've tried to have a super regulator, somebody who regulated like the CFPB over multiple jurisdictional areas, you get a lot of political difficulty in implementing rules. So I think it'd be great if we could get something like that, because we don't have the ability to push rules to the states, and because we have these territorial existing territorial borders between securities, commodities, and they don't fit perfectly onto the way digital assets work. I'm not very optimistic that we're going to see something like MiCA in the US anytime soon.
Yeah, let's see. Maybe MiCA will be very successful. So thank you.
I agree. I mean, that is the one, this is an area of great experimentation. And I do think that the US does look to the EU for, to see how this is going to work. I think this experiment could, if successful, could provide the impetus for regulators in the US to try to adopt some of these, some of the features for sure.
Yes, that's the point. So now I would like to ask Tavi, could you please tell us a little bit more about the practical side of MiCA regulation, like its scope and application? What are the benefits? We could show to our US colleagues maybe what the future holds in EU and maybe someday in the US.
You're muted.
Tavi, yeah.
Apologies for that. Absolutely. So in essence, MiCA targets the entire crypto asset industry by categorizing its participants to either crypto asset issuers or crypto asset service providers, or CASPs as they are more commonly referred to. While at the same time, some assets and activities are exempted from its application. For example, NFTs or services that are provided in a limited environment or DeFi. However, to be exempted, certain conditions must be met. And in terms of DeFi, it's important to understand that decentralization has different degrees. And it really depends as much on the underlying protocol as it depends on the governance arrangements that would make the issuer or the CASP truly decentralized. So in some instances, a permissionless DLT may not be enough to consider a DApp decentralized if the entire commercial decision-making, along with the maintenance of the protocol, is ensured by a closed group of beneficiaries. The fully permissionless, fairly launched Bitcoin is obviously the benchmark for decentralization. However, it's one of a kind. So the actual extent of decentralization should be evaluated individually. Now, in terms of crypto assets, the regulation identifies two major groups: stablecoins and non-stable coins, that can range from utility tokens, fan tokens, and all other crypto assets that fall under this blanket definition. And finally, in terms of CASPs, the regulation identifies 10 different services that can be provided after completing an authorization process by any legal entity or undertaking, which by definition could include decentralized autonomous organizations. Now, once the CASP is authorized to provide its services by one member state, it can do so across the entire EU without any restrictions. So that's the MiCA regulation in a nutshell.
Thank you, Tavi. Really very comprehensive, at least for me, and very short presentation of such a big document. I would like to ask now our US colleagues, let's look into the US regulation. So Bertrand, could you please tell us about the possibilities and perhaps limitations that crypto asset issuers face in light of crypto asset classification in the US? What examples?
Right. Right. I mean, I'm certain that Jeff has scared everybody about the extent of the regulation and how difficult it is to comply and to know exactly what you have to comply with. But one area where the participants have been very focused is token issuance. And because we don't have a statute like MiCA where the various functions are specifically set out, this has been regulated. This is one area where there's also been a lot of activity in terms of regulation. The issuance of the tokens is the regulation of the issuance of the tokens really turns on whether the tokens are securities. So this has become a very important first step of analysis for anyone in the U.S. who is looking to enter the U.S. markets with a digital asset. The key test that the SEC has applied is called the Howey test. And while this was somewhat of a academic concern 10 years ago, when Jeff and I first were entering into this area in I guess 2014, it quickly became clear that this test from 1946, which regarded the treatment orange groves was going to be the primary way that people were analyzing tokens. Now, the Howey test has 4 prongs, and this test was set out by the Supreme Court, trying to give some substance to a part of the definition of a security that does appear in the statute, that includes among the litany of things that are securities, and most of the things in that litany are things that you would expect to be securities: equity shares, stock, rights, mineral participation rights. But that list includes a thing called investment contracts, and investment contracts doesn't have a formal definition in the statute, so the courts have devised that definition. The definition is created by the Howey test, and the courts then find that an investment contract exists if there's an arrangement that involves the investment of money in what they call a common enterprise, with the expectation of profit from the efforts of others, the expertise or efforts of others. Now, what's interesting about the test, and it comes up when you start to look at the Ripple case and some of the more recent litigation around the Howey test as applied to tokens, is that what's being analyzed is the arrangement, a set of contractual arrangements, and how you define those arrangements can really dictate whether you find a security or not. So not to get hung up on oranges, but in the example of the original Howey case, no one thought that oranges were securities, but they did recognize that there were a series of contracts where people would buy a rateable portion of an orange grove. So you would have one tree, say, that was your tree, but then you also engaged a service provider who would harvest the oranges, take the oranges to a market, sell the oranges, and then split the proceeds based on how many trees you own. So that the court looked at that overall arrangement, which included the harvesting and the sale and the sharing of the profits, to determine that entire arrangement was a security. So that's what people have done when looking at tokens. Is the token part of an existing arrangement, which may include various features of the token that recreate that idea of an investment of money in a common enterprise, the expectation of profits to be derived from the efforts of others. The SEC issued what they called the framework for digital assets in 2019. And what that did was affirm that the SEC, among other things, that the SEC is viewing the Howey test as the key test for examining tokens, that they would apply it. I will note that in a kind of famous footnote 10 in that framework, the SEC said they don't think that they're held to this common enterprise prong, and that they think the courts have invented that, but that's not a necessary part of the investment contract analysis. It remains to be seen if that survives, but it does mean that a couple of things have become the focus for people who are issuing tokens and want to evaluate if they can not be treated as a security. And we come to, in a second, I'll talk about why it may or may not be important to be a security. If you want to not have your token be a security, you can eliminate the expectation of a profit. Now, a stable coin, properly conceived, might not have an expectation of a profit because the coin is meant to have a fixed value or a value that's fixed to an existing asset. The other point of weakness or a point of attack, and by the way, each of these prongs has to be met. So if you can show that one of the prongs doesn't apply to your token or to your token platform, then you're not a security. So deriving the profit from the efforts of others is another area of a potential channel for not being a security. So in that case, especially for highly decentralized environments, the theory would be that while there might be a profit to be had in holding a token, that profit is generated by market forces, and you're not really, and although you may be relying on people to continue to trade in that token, maybe even to make enhancements to the software, you're not relying on a specific group, you're relying on a very large decentralized group. And that's been somewhat of the analysis that's been applied to Bitcoin, somewhat unofficially, that in the case of Bitcoin, while people do hold Bitcoin for investment purposes, the rise and fall of Bitcoin prices isn't due to the specific efforts of an identifiable group, but the efforts, including the trading, of a very large and diffuse group. And so that prong of relying on the efforts of others is not available, and so that's not security. Why it's important to determine if a token is a security is it really does go to this exact issue you raised, Inga, about issuance. Issuances of securities in the U.S. are highly regulated. Typically, companies are required to register securities to be that are going to be publicly offered. And of course, tokens, by their nature, because they're on unless they're part of a private blockchain, because they're on a public ledger, are transferable among members of the public. But the registration process would be pretty onerous for a token issuer. Potentially not even, it doesn't really fit very well for the way that tokens are structured. Many of the disclosures don't actually make sense for a decentralized platform. So if it's a security, then you would have to comply with specific rules on a private placement, which would dictate not just how the tokens could be offered, but also how they could be resold. So without getting into a lot of detail about the limitations on resale, the application of these rules could be quite difficult and basically pretty contradictory to the way that tokens really work and are traded. Similarly, we've already seen with Coinbase and FTX, if the tokens that are being traded on an exchange or securities, then those exchanges are from the SEC's perspective, securities exchanges, and then rules apply to those securities exchanges, including insider trading prohibitions, but also registration requirements. And we haven't seen those play out in full yet, but these are the requirements that would make it pretty preferable if you're issuing a token to not be to try to structure your token so that it's not a security in the U.S.
That's really very interesting. Not so easy, I believe, as to read the laws. So now
it's another good example of the law being driven by court cases rather than by.
Yeah. It's quite complicated, and you need to have to read the court case and to have explanations of the professionals next to it. So I would like to ask Tavia, could you briefly explain how MiCA regulation tackles crypto asset issuance? Maybe it is easier in Europe than in EU or than in US. How all these assets can be tackled or will be tackled in the EU after MiCA will come into force?
Sure. Well, in very simple terms, and as mentioned before, the regulation identifies two major types of crypto assets. These are stable coins and non-stable coins. So in terms of non-stable coins, if they are issued not for the purpose of offering them to the public or admitting them to a trading platform, then their issuance is largely exempted. However, if a crypto asset is issued for the purpose of being offered to the public or to be admitted to trading, they should be issued by legal entities, for one thing, that have notified their competent authorities with a white paper, which should include, among other things, the information about the issuer, the crypto asset, the underlying technology, and the description of any adverse impacts on the environment that their chosen consensus mechanism may cause. So that's the issuance based on the MiCA regulation. Basically identifies different issuers and classifies different assets that are issued.
So what you are saying is that the issuers of the crypto assets that are listed on the exchanges, on the crypto exchanges in the EU today, would need to be registered as legal entities in the EU and to draft their white papers according to the MiCA regulation?
That's right. Yeah, that's right. These and other requirements would basically apply to the majority of crypto assets that are listed on exchanges or outside of them that can be acquired by retail investors today.
And about the stable coins, which were touched by our colleague from US as well, They are really among the most highly maybe debated topics that take a center stage in MiCA regulation due to their interoperability and the risks they might pose to the financial system if their influence could be very high and left unchecked. So, Tave, could you please explain how they are regulated under the MiCA regulation?
Sure. So just to bring everyone up to speed on what stablecoins are. So stablecoins are crypto assets that maintain a stable one-to-one value in reference to a fiat currency. So in essence, MiCA identifies two kinds of stablecoins. These are asset reference tokens, or ARTs for short, and e-money tokens, or EMTs. The difference between them are the entities that are allowed to issue them and the assets that can be used to maintain their stable value. So in regard to ARTs can be issued by any legal entity or undertaking after they are authorized by the regulator, and the value of ARTs can be backed up by any assets, like other crypto assets, equities, you name it. The authorization process will evaluate the applicant's governance arrangements, the ART's underlying technology, including the necessary infrastructure like the dependence on third parties. So in addition, applicants will have to provide a legal opinion that the ART does not qualify as either an exempted crypto asset or an EMT, and they will have to prepare a white paper. Now, on the other hand, EMTs can only be issued by either electronic money or credit institutions. And contrary to ARTs, the stability of an EMT's value can be backed up only by highly liquid assets. In addition, since EMIs and credit institutions are already licensed entities, they would only need to notify the regulator about their intention to issue the EMTs and provide its white paper. So no formal per se authorization process will take place, only a notification, which has its own nuances, but only a notification. And as a secondary process for both EMTs and ARTs, if certain criteria are met, both ARTs and EMTs can be also considered as significant, but that's a wholly different subject and discussion.
Thank you, Tavi. So it seems like both the EU and US have the same point of view on the need to differentiate between crypto assets regardless of how they are classified. And the structure of that classification could help businesses to be certain that the crypto assets that they issue correspond to their business goals. Jeffrey, could you please provide an overview of the different kinds of the most common crypto activities provided by crypto asset service providers and how they are regulated in the US?
Sure. So a lot of cryptocurrency companies, when they first started out, tried to do everything. They would try to issue a token, transfer tokens, hold assets on behalf of other parties, open up marketplaces. They would propose that they would start doing like payments to employees. They would do everything. And then as they started to become more familiar with the regulatory regime, they started to focus on, one or a couple of primary aspects of cryptocurrency transactions and business activity. So one of the main areas, and this corresponds to an existing regulatory regime, is money transmission. So one critical thing for any company that is outside the United States and wants to do cryptocurrency business in the United States to think about is whether or not they may be treated as a money services business because they're engaged in money transmission. And often this doesn't occur to people because, for example, if I'm, selling buckets, I don't think of myself as a money transmitter. And the reason for that is because when I sell buckets, people make payments to my bank. And my bank deals with all the regulations that apply to payments and money transmission and anti-money laundering activity, et cetera. But people that are engaging in similar forms of transactions with virtual currency, they're often not dealing with the bank. And so they may in fact be taking money directly from one party, They may be sending it to another party, and they're not using a bank account. They're using a wallet that they themselves control. Under certain circumstances, this can end up making them into a money transmitter, even if they don't think of themselves at all as being a money transmitter. So FinCEN regulates money services businesses and money transmission. And anyone who is going to be thinking about whether they might be subject to that regulation, the main thing that they want to think about, and this was set out in a 2019 guidance, I'd be happy to send anyone if they're interested, is whether they're accepting convertible virtual currency and then retransmitting it to another party, but not on their own account, but rather on behalf of some other party. So if I receive a cryptocurrency token and then I use that token to pay my own rent, that's not, that wouldn't necessarily make me a money services business. But if I receive a cryptocurrency token from a customer and then that customer says, could you send that to my landlord? I would like to pay my rent. And you then do that, then that can make you a money services business. You may then have to register with FinCEN and implement an entire anti-money laundering program and have a chief compliance officer and be subject to a pretty broad array of federal regulations.
So, and do US states also regulate money transmitters, or just on the federal level?
Yeah, that's a great question. And yes, they do. In fact, in a way, the states often end up becoming the primary regulator for some of these money services businesses. And the reason for that is when you're registering on the federal level, it's a pretty simple process. You fill out a registration form, you send it off to FinCEN, but FinCEN doesn't then view itself as a prudential regulator. So earlier I mentioned that there's these banking regulators, and if you're a bank, you're familiar with a very close relationship that you often have with your bank regulators. They, may be on site every year. They'll demand that you send them a lot of information. They'll verify the accuracy of a lot of that information. They'll check on your financials. They'll check on your disclosures to consumers, et cetera, et cetera. FinCEN doesn't generally have that attitude towards people or entities that register with FinCEN. They accept the registration, they put it on file, but they're not necessarily involved on a day-to-day or even a year-to-year basis. In contrast, state regulators tend to have a more active role. So if you're going to if you're going to engage in money services business activity in a given state, you generally will have to go to that state and apply for a money transmission license. And that licensing process can be expensive and can involve a lot of scrutiny from the state regulator. So that can take longer. It can be a lot more burdensome. And you might have to do it 50 times. So with a federal regulator, there's one federal regulator. But it's very easy to inadvertently start doing businesses in all 50 states. Because if you imagine like a FinTech startup and they're selling widgets online, they're taking cryptocurrency, they're sending cryptocurrency, they want as many customers as they can get, and it doesn't really occur to them. These customers are spread out over 50 different states, and that may mean I now have to go apply for 50 different licenses.
It sounds really very challenging for CASPs in the United States to ensure that they are complying with all the state regulations. So what is going on in the United States right now with regards to the application of securities laws to CASPs? Jeffrey?
Sure, yeah, I'd be happy to go over that. So, so I just was talking about FinCEN, which applies to money transmission. But earlier we talked about the SEC and the CFTC, which are more focused on regulating investment activity. And earlier in our discussion, Bert gave a description of the Howey test and how the concept of an investment contract is being applied to cryptocurrency tokens. Right now, there is one very fundamental dispute that is going on between the SEC on the one hand and a lot of cryptocurrency companies on the other hand. And the essence of that dispute is this. When Bert described what an investment contract was, the focus was on the contract. So he said, in the Howey case, there were some oranges that were involved, but there were parties that entered into agreement. There were the people that ran the orange groves. There were people that invested in the orange groves, and they signed a contract. That contract was deemed to be an investment contract. that contract and the overall arrangement were deemed to be securities, but the oranges weren't deemed to be securities. With respect to cryptocurrency tokens, the SEC is taking the position that not only the agreements that are entered into between the seller of the token and the buyer of the token, not only is that a security, but the actual digital asset itself, the actual cryptocurrency token itself, is a security. If that's true, then every time a token moves around and gets transferred from one party to another, that becomes a regulated securities transaction. And every platform that facilitates those forms of transactions can suddenly be subject to, regulation as a broker-dealer or regulation as an exchange. So there's a real active dispute right now. The dispute is taking place in federal courts. The SEC has won some, the cryptocurrency companies have won others. But it's still really an open issue. And how that is decided could fundamentally alter how cryptocurrency companies end up being subject to regulation. Because if you're a company that just takes tokens and transfers them to another party and they're not securities, then you're not going to be subject to securities regulation just by virtue of that activity necessarily. But if it turns out that the tokens themselves are securities, then all of a sudden, many platforms that are currently operating both in the United States and outside the United States would suddenly be subject to treatment as a securities exchange or a broker-dealer or myriad other securities-specific regulations that otherwise wouldn't necessarily apply to these cryptocurrency companies. So that's playing out in the courts right now. And as I said, the outcome could have an immediate and significant impact on how cryptocurrency companies operate inside the United States.
It sounds like the US is having really difficulty creating a stable regulatory environment, to facilitate to have a crypto valley in the US, and where can, to be at the forefront of the development of a distributed ledger technology. So we think that in the EU we have a little bit better position now. So I would like to ask Kęstutis, could you please tell us what are the current trends for crypto and what is the role the legal advisors play during this transitional period until the full implementation of MiCA regulation?
Yes, everybody is expecting MiCA to come and looking into MiCA. And here in Lithuania and the EU, we consult the very different type of companies that might be the crypto asset marketplaces, might be crypto exchanges, crypto wallet service providers, swaps, companies tokenizing real world assets, as well as the stablecoin issues. Actually, all these companies, they will be considered as the crypto asset service providers or CASPs, and it is very difficult to isolate a single crypto trend in Europe. But but one thing is very certain, that the CASPs are becoming much more aware that almost all activities will be regulated by MiCA, and the companies currently proactively seek the legal guidance on how to start preparing for the reauthorization or the new authorization process which will be implemented next year. Even the predominantly DeFi CASPs are making sure that their activities are sufficiently decentralized to fall out of the MiCA scope. A significant fraction of CASPs are also crypto asset issuers, which means that even two different processes are necessary for full compliance of their activities. In regards to crypto asset issuers, the most important task for any issuer is to understand what sort or what kind of crypto assets it intends to issue, because based on the type of the crypto assets, the process and the requirements might differ dramatically. Secondly, no matter what crypto assets the company wishes to issue, all of them will need to have the white paper, which is fully compliant with, which needs to be fully compliant with MiCA requirements. Third point, the company should be aware that it is important to establish a working infrastructure for the company's activities. This means not only to ensure the sound governance arrangements, but also to prepare the comprehensive program of operations describing activities that the company is going to carry out in relation to crypto asset and the company business model. And lastly, it is exceptionally important to understand that companies are using self-sufficient and are able to operate with companies which provide the services to them. It means that it is not only, you need not only to ensure that your own activities are fully compliant with the MiCA regulation, but you also need to be sure that the services you outsource from the other service providers or your partners are also compliant to MiCA. This could be particularly important to the crypto exchanges that list crypto assets in their platforms. They need to be sure that not only their services are compliant, but the crypto assets they intend to list are fully compliant to MiCA as well. So in short, there are almost no CASPs whose services are not within the scope of the services listed in MiCA.
Thank you, Kęstutis, for both insights and advice to the crypto market participants. What about the US, Jeffrey? Could you please give us some details on what the current crypto trends are and what are the most common issues that crypto market participants face in the US and how you lawyers can help?
Sure, absolutely. Well, as I said, a couple of the major issues that anyone coming into the United States have to deal with are the application of FinCEN's money transmissions laws and the application of the way the SEC is interpreting securities laws. And what we often find is when people come to us early in the process, we can advise them on ways to change their product or ways to change the way in which they partner with other US companies that save them a lot of money in terms of their regulatory compliance burden. Whereas when they come to us later in the process and they've already hired coders and built out a whole platform, but it turns out that platform violates some US law, then they have to start over from scratch and spend a lot of money. So a big part of what we do is try to save our clients money by guiding them towards the most efficient process possible to do business in the United States while complying with US securities laws and money transmission laws.
Thank you, Jeff. And do you, Bertrand, have anything to add here?
Well, I would just say, even if your takeaway from today's presentation is you don't want to have anything to do with the U.S. regulatory environment and you don't want to operate in the U.S., even then it may be worth having a conversation with us because the jurisdictional reach for some of these U.S. agencies is quite broad, or at least they think it's quite broad. And so structuring yourself just to be sure that you're not within the ambit of the U.S. regulators can also require some some advice from us about how best to structure things.
Yeah, sure. Thank you, Bertrand. So, well, it seems that both the EU and the US are in the agreement, at least in principle, on the need to regulate the crypto asset market. The basis for that regulation might be very different, but the approaches might be distinct, but therefore, one could undoubtedly argue that legally certain facilitates investment and the development of an industry. Perhaps the most valuable underlying message that was spoken during this discussion could be that the crypto market is no longer the Wild West. Regulation is coming, and it is important for all market participants to be informed about the regulatory changes, no matter which jurisdiction they choose for the activities. So this concludes our panel discussion, and I'd like to thank our guests for sharing their insights in the world of crypto asset regulation. And I'm sure that this discussion is only one of the many more to come. So I hope that next time we meet, we will have even more practical information to share. And likewise, I would like to thank our audience for joining our discussion. And I hope that it was informative and you heard something useful that will get you started on your journey to regulatory compliance. Having said that, we would like to hear from you. Please share your observations on crypto regulation. Send us your questions. We have several and we will follow up with them through our emails. And we will try to do our best to keep you informed. One last thing, wherever you've missed some parts of this discussion or you would like to listen to it again for your convenience, as I said, we will circulate the emails not only with the answers, but as well with the discussion recording. Feel free to share it with your friends or colleagues that are interested in this topic and couldn't join us live. Thank you for joining, and until next time, bye.
Thanks, Inga.
Thank you.
Thank you.
Bye.